Testing Justice 7. Testing Justice 6. Testing Justice 5. Testing Justice 4. Testing Justice 3. Testing Justice 2. Testing, testing lavalier microphone. Testing lavalier microphone 1. Testing lavalier microphone 2.
justices of the Supreme Judicial Court, sitting in the law court of Portland within the state of Maine, may come forward and declare, and they shall be heard.
Good morning. You can be seated. The first matter before the court is Androscoggin 24-477 regarding the weapons restriction of T. We are being streamed on the web, both by audio and by video. I see counselor present. Apparently, Attorney Griffin is raring to go. But I would ask first that both counsel identify themselves by saying their names for the record, together with the party they represent, starting with the appellant.
Good morning, Your Honor. Henry Griffin, ready and raring to go for the appellant.
Good morning. Catherine Hudson McRae, representing the state of Maine.
Thank you. And Attorney Griffin, we're happy to hear your argument.
Thank you, Judge. Good morning, Your Honors. May it please the court, representing the appellant in this matter, I have essentially proffered one argument in this case that is based on two sub-arguments. Primarily, I'm arguing a due process violation in this case, a substantive due process violation. I know the state has questioned whether or not it was a procedural one or a substantive. I believe by the body of my brief that it was clear that it was a substantive issue. In this particular case, we're dealing with a statute, Title 34B, Section 3862-A, commonly known as the Yellow Flag Law, which provides a procedure by which the lower court has to find by clear and convincing evidence that it is highly probable that my client presented a likelihood of foreseeable harm to himself or to somebody else. So the process that is being used by the courts obviously provides for a hearing to be had by a judge within 7 days after a temporary order issues. In this particular case, that hearing occurred, and in that particular case, a nurse practitioner testified. Now, the state, in its brief, as you know, argued that the nurse practitioner, whether her testimony was good or was bad, was simply not necessary, that the statute itself allows the court to formulate a final order in this case without the opinion of a medical professional, and I believe that is completely wrong. If you look at this court's decision in Ray J, which has been cited by both parties, a 2022 case, the court in that particular case, talking about the Second Amendment and whether or not it can be modified, stated that there were certain reasons that, of course, the Second Amendment, or in this case, Article 1, Section 15, could be modified, stated, 16, excuse me, that the legislature intended that one type of reasonable limitation on this right, the right to possess firearms, could be based upon the mental health of a citizen. I think it's crystal clear that that case in Ray J, which was a weapons restriction case, allowed that it would be a basis for modifying a person's constitutional right to bear arms based upon mental health. It is, I think, impossible to argue that the Yellow Flag Law is not premised in mental health, and therefore, when you look at the process that's included in the statute itself, that is basically broken into two parts. There's the initial order that issues based upon the proffer by a medical professional that a person is suffering from a mental illness. So if you look at the statute, you look at the definitions, we're dealing with something called a protected person. Right from the start, the mental health professional has to find that this is a protected, a restricted person. That cannot happen unless a medical professional finds that a person presents a likelihood of foreseeable harm. That determination is made right at the start of the process, not involving the judiciary. By the time you get to paragraph 6 in that statute that talks about the hearing itself, we're still talking about a restricted person, meaning we're still talking about someone who presents a foreseeable harm. That determination, which was made
Counsel, I see that the green light is on. I guess I'm a little confused about your argument at this point. I understand the issue that the medical evaluator, the nurse practitioner, I think it was in this case, did not actually talk to the protected person, and so the evaluation was really just, the initial evaluation was just based on whatever the police told her, basically, right?
essentially.
Okay. And then she testified, but same thing. She didn't have anything to add. She still had never personally evaluated or interviewed the protected person, right?
That's correct.
And is your argument premised on that somehow that is inappropriate?
It's not inappropriate. It's inadequate. The court, in the case of In Re J, talked about,
So whenever, if you have somebody who's seriously mental ill and unable, a different, I'm not saying this is your client, but let's assume in a different case, you have somebody who is very, very mentally ill and unable to cooperate with the evaluator, therefore you cannot take away that person's weapons?
no, that's not the case at all, Judge. What I'm talking about is not the condition of my client's state of mind. The condition is that the person who is a trained professional has to do their job. In this particular case, she did nothing. And so that is, my position is that that is simply not competent evidence that was presented.
Counsel, can I?
What she should have done is she could have set up a meeting. She could have gone to the hospital. She could have consulted with the doctors at the hospital where he is being restrained. She could have talked to more than one police officer whose name she didn't know. There's all kinds of things she
But
could have
isn't
done.
the initial evaluation moot by the time you get to the judicial hearing?
Well, if you want to argue that it's moot, then we need a second finding of restriction, because the statute from paragraph 6 on continues to talk about a restricted person.
Counsel, can I be clear about your argument?
Sure.
Is your argument premised on the position that the nurse practitioner here did not give an opinion?
No. My argument is that her opinion was not competent.
And it's not competent because she didn't actually meet with the individual?
Because she didn't actually provide any basis for her opinion.
Well, isn't it true that most psychiatric diagnoses are based on observable behaviors?
That's certainly part of it, but it's
Well,
also based
isn't it
upon reviewing other records and consulting with other professionals.
Isn't it? But didn't she have enough information here to observe this individual's behavior, both in terms of the reports from the law enforcement, listening to the 911 calls, or the other audio evidence? I mean, there was plenty of evidence here, plenty of facts from which she could derive an opinion, isn't there?
Well, there's no evidence that she listened to any of that evidence prior
All right, well,
to formulating her
then just
opinion.
take the police affidavit. Just take the report from the police.
Okay, but in these cases, the parties are required to rely upon third-party information by a person who had personal knowledge or observations of the defendant. There is nothing.
The mother
They
did.
observe the defendant, have interactions with the defendant? Wouldn't that provide a basis for her to reach an opinion in light of their interaction?
There is no evidence that the officer who spoke with her on the phone actually observed my client. And
But
so,
experts rely on what is otherwise hearsay all the time in formulating their opinion, and in fact, our expert rules make it clear that they can do that.
yes, and the statute makes it clear that they can do that in this particular case. But the statute also specifically requires that the informant that they're relying upon had personal observations of my client or conversations with my client, and that didn't happen in this case.
I'm trying to drill down on your argument. At page 13 of your brief, you have a statement there. Looks like a triple negative, but I think I can get to what you're getting. It says, this statute does not appear to countenance an assessment that does not involve the non-involvement of the person. If I wade through the triple negative there, it sounds like you're saying...
I could have written that better, I agree.
I think I know what you're saying, but I'm going to ask you right out. Are you saying that if the assessment doesn't involve the person, in other words, face-to-face, you're saying, case closed, this does not ring the bell under the statute?
No, I don't. I think that's part of the argument. They can clearly rely on hearsay if my client doesn't cooperate, Judge.
Okay.
And to you, Justice said, I agree that even if my client doesn't cooperate, we can issue an order as long as the evaluator relies on competent evidence. And
Okay,
there
so the
isn't.
subject to one of these things can't simply say, I'm not going to talk to you, and then defeat the whole process.
No, absolutely not.
Okay.
And this is a discreet argument, I understand, based upon the specific facts of this case.
Counsel, as you mentioned in your opening, the state has suggested that no medical opinion is necessary when it gets to the final hearing, and the statute doesn't seem to say that it is. Is it your view that in the absence of a medical opinion at the final hearing, the statute is constitutionally infirm? Is that what you were saying?
If I understand your query correctly, my argument is that a mental health assessment is a vital component of a final order under paragraph 6 of this section.
But does it say that?
It doesn't say that, but I think if you look at the language of the statute, when it talks about restricted person, right, when it talks about protective custody, that is throughout the statute. So it doesn't stop at paragraph 6 when we get to a final hearing. It goes on through after that. And if you look at subparagraph C of paragraph 6, it talks about a person who, let me make sure I get it right, sorry.
I mean, it uses the language of restricted person, certainly, but that's just defined as someone who's taken into protective custody when the officer had probable cause to believe, and it goes on and on.
Yeah, but also we have to have a finding. My argument is there has to be a finding that the restricted person continues after the final hearing, because this is not referring to the past. This order is referring to the future. For instance, the court, this is what it says in paragraph C, the court shall consider whether a restricted person is receiving treatment to that person's mental health or substance use needs, which means if the judge finds that they are receiving treatment, the judge could find this person is no longer a restricted person, right? But I think we still need expert testimony at the time of that final hearing for the judge to review whether or not, in fact, my client is still a restricted person.
But again, on that expert testimony, going back to subsection 2, titled Assessment by a Medical Practitioner, it says, notwithstanding any provision of law to the contrary, the law enforcement officer shall provide to the medical provider the information that led to the protective custody, including but not limited to information that gave rise to the probable cause determination. So it anticipates that the police officer is going to communicate to the evaluator all the stuff that went into the original concern.
I agree, and that's what they're supposed to do. What I'm saying is that's not enough for the final order.
So can the evaluator consider everything the officer reported to him or her?
The evaluator is required to.
Okay.
The question is, this initial order is granted without any judicial intervention at all, only based upon the word of a nurse practitioner, right? That's it. And so my client's constitutional right to bear arms, freedom, all those are
But then there's a
impacted.
hearing, and at which there is other evidence.
Right. But that other evidence has to result in a separate judicial finding that my client is a restricted person.
And that judge made, I guess I'm confused. Can I ask you maybe a different question? Because what I thought your argument was, but it sounds like it's not, but I'm going to ask it anyway, was that essentially that the evaluation by the nurse practitioner together with a lot of the other evidence was all so attenuated. I mean, it's hearsay. It was sort of hearsay upon hearsay in a lot of it. And although the statute permits hearsay evidence, we have said in the context of probation violations that if hearsay is unreasonably abundant and substantive reliability suspect or highly suspect, a decision founded upon it may be subject to vitiation for violation of due process of law. That's what I thought you were arguing, but you're not, apparently, as in Karen and in James.
So
I guess I'm confused.
see if I can help. So my argument, I've tried to keep it as basic as I could because this is strictly a due process argument, and I'm basically
Well, and I just gave you a due process argument, but I guess it's not that.
Well, it is that. So my interpretation of due process is that, and it's fundamentally unfair for the court to base a final order on evidence that is not competent.
Okay.
Okay?
Thank you.
Okay.
You'll have a couple minutes for rebuttal, so.
Thank you, Judge. Thank you, Your Honor. I appreciate it.
Attorney Hudson McRae.
Good morning. May it please the court, I did not take any protective time, so I'm happy to answer any questions. Listening to questions by this court of opposing counsel, it seems like the real issue that the protected party raises is that the initial restriction that was sought and was subsequently judicially endorsed before it even went to that final hearing was the real issue here for the protected party, and that the medical determination by the medical practitioner was not competent evidence. And
But it seems like it's holistically. I mean, don't we have to look at this holistically in terms of the competence of the evidence? We have a nurse practitioner who's basing it on hearsay, and I understand that that's not necessarily improper, but nonetheless, no actual evaluation or observation. The state called the in-home provider, but not the mother or anyone who was, who was actually allegedly assaulted here. And then the police. And it seems like it is, the entire case was founded upon essentially hearsay in terms of what happened certainly to start the standoff. And we have said that although a proceeding permits hearsay, there is a level at which it's too much, essentially, and that would violate due process.
I don't think that is the case here. The judge heard the mother's 911 call directly, saw the photographs of the protected party holding a firearm to his head.
And are you suggesting that the 911 call would have been admissible as an exception to the hearsay rule?
That is my contention, Your Honor, yes. From the state's perspective, I don't think all of the evidence that was presented at the hearing rises to such a level that this court has previously said is suspect and violative of due process clause in probation hearing context. I don't think that is the case here. This evidence is qualitatively different. You heard the district court judge heard the approximately 20-minute phone conversation between Detective Sibley and the protected party himself discussing a myriad of issues. But getting back to what the state believes is like the core issue raised by the protected party here, it's that the protected party believes the medical assessment by the nurse practitioner was inappropriate. And from the state's perspective, it is entirely impractical for, in these types of proceedings and in some other proceedings, for the medical practitioner, as the court noted, to interact directly with the protected party, especially where there are serious issues of mental health. As Justice Meade indicated, the statute makes clear that the nurse practitioner and the medical practitioner must take into consideration, shall take into consideration information raised by that law enforcement officer in the probable cause determination, and then that medical practitioner may rely on other information if it meets certain requirements.
I'll ask you just hypothetically, not this case, but in another case, when the evaluator's opinion is demonstrably and obviously not competent. Let's just imagine some ridiculous situation where it came in and everyone agrees that this doesn't fly. Would that destroy the entire process, the lack of an evaluation, lack of an assessment by the evaluator?
I think that situation would arise when the application for the weapons restriction order needs to be judicially endorsed. When it
But
goes,
let's assume the judge endorses it.
then I think when it gets to the full hearing part, assuming the state does in fact call the nurse practitioner, because even though I did argue that it's not necessary, it happens almost always that the nurse practitioner or the evaluating medical practitioner testifies by Zoom remotely before the court. I think that would then, the court at that point at the hearing would resolve the issue. If it was so wholly incompetent and the state presented no additional evidence to support that, I think a court...
What if there was additional evidence? I guess the question is, how important is the medical provider's testimony, or could the court go forward without it, assuming there's other sufficient evidence?
At the hearing, and I think that's what happened in this case based on my review of the record, is that even though the nurse practitioner was called to testify, provided, I think, largely to some extent duplicative information than the evidence that was presented to the district court judge. The district court judge did not reference the nurse practitioner's findings or opinions or experience in coming to that decision, and I don't think that renders the district court's order of the weapons restriction voidable.
What if the initial evaluation is a non-starter?
The judge endorsed it anyway, but...
Yes.
Endorsed it, but the original was just, imagine some confabulated example.
It was, the caseworker who frankly has no expertise or something like that.
Then yes, and under that hypothetical, that could be the case.
Okay, all right.
But I think it would ferret out in the process by the time it went to hearing.
The protected party is given notice of the hearing,
Correct.
has an opportunity to appear.
Yes.
And to present evidence.
Yes.
Did that happen here?
Yes, and every person is given court-appointed counsel. To my knowledge, there are plenty still taking cases for weapons restrictions. But
So in the circumstance where the medical practitioner's opinion is highly unreliable, the protected party would have an opportunity at that hearing to contest it.
Yes.
Yeah.
And I think that's why there's no due process violation with the statute substantively or procedurally as applied or on its face. I don't think there is a constitutional problem with that, although I'm still slightly confused about the due process argument.
Yeah, is this substantive due process or procedural due process?
I
I think
interpreted.
she's the one who said if she was confused, which
Well, I'm confused about that.
My reading of the brief was that this was a procedural due process, which is why I argued that. It was clarified this morning that it's a substantive due process. I
If
think
it's substantive, doesn't it have to shock the conscience?
that's my recollection of some of the case law
I mean,
around
that's
this.
when you brutalize the person and things like that, not if the evidence is unreliable and you have an opportunity to oppose it, and you're using Matthews versus Eldridge. That's procedural, isn't it?
That was my review and interpretation of the brief, yes. was
And
that it was a
didn't we foreclose the procedural due process issue in Ray Weapons restriction of J?
I believe so, although my recollection was that it was primarily focused on a Second Amendment challenge.
It was, but we said there as well, the statute also provides procedural due process.
Yes.
Counsel, can I ask you, is the order still in effect or has it expired?
There was it would have expired, but for the state filing through the district attorney's office an extension that is currently still in process because another evaluation needs to be obtained, and that is in process.
So you haven't argued any mootness issues then because it's still pending or could be extended?
Correct. And he is, we are working on getting another evaluation by a medical practitioner, yes.
Thank you.
With no further questions, the state rests on its brief and requests that the court affirm the judgment. Thank you.
Thank you. Attorney Griffin?
Further to argue, if you have additional questions, I'd be happy to try to answer them.
There don't appear to be.
Okay, thank you very much.
Thank you, counsel. Then with that, we will be in recess on this matter. As is our usual practice, we'll be taking the matter under advisement and issue a written decision in due course.
All rise.
And good morning, you can be seated. The matter before the court is BCD 24-566, Golden Anchor versus the Town of Bar Harbor, although this is the appeal of Mr. Sidman. If we are being streamed live on the web, both by audio and by video, if counsel who are arguing would introduce themselves by saying their names for the record together with the party they represent, starting with the appellant.
Good morning, Your Honors. I'm attorney Bobby Papazian here on behalf of appellant Charles Sidman, and with me is my colleague David Silk from Curtis Thaxter.
Thank you.
Good morning, Your Honor. Jonathan Hunter for the Town of Bar Harbor.
Your Honor, Timothy Woodcock for Golden Anchor, and with me at council table is Jenna Gow.
Thank you. Attorney Papazian, if you're ready to proceed, we'd be happy to hear your argument.
Thank you, Your Honor. I'd like to request 3 minutes for rebuttal.
I have indicated that, yes.
Thank you.
You're all set.
All right. May it please the court. I'm attorney Bobby Papazian here on behalf of appellant Charles Sidman, and with me is my colleague David Silk from Curtis Thaxter. We are appealing from the business court's denial of Mr. Sidman's motion to intervene as of right. We're requesting that this court reverse the denial of intervention and remand back to the business court with instructions to allow Mr. Sidman to intervene as a defendant intervener. Although the standard of review is for an abuse of discretion, that abuse is circumscribed by the law, which requires granting a motion to intervene as of right when certain criteria are satisfied. And that circumscription of the law has been discussed in cases like T-Mobile v. Northeast, v. Town of Barnstable, and International Paper Co. v. J. The criteria for intervention as of right are threefold. First, the intervener has to have an interest in the subject of the litigation. Mr. Sidman has three interests that are worthy of recognizing. The first is his business interests. He owns a art gallery in downtown Bar Harbor that is harmed by the influx of cruise ship passengers into the downtown area. The economic harm that he suffers has been demonstrated, and potential economic harm is sufficient to convey interest to intervene. His business interests are the other side of the same coin. The disembarkation of cruise ship passengers directly harms Mr. Sidman's business. And the town seeks to minimize Mr. Sidman's interest because he's not in the same line of business as disembarking passengers himself. But you don't have to be in the same line of business to have an interest in litigation. If you had a fine china shop next to a quarry who is challenging blasting regulations, you wouldn't say that the china shop doesn't have an interest in the quarry's litigation. And so the same is true here. The second interest he has in this litigation is the disembarkation of cruise ship passengers interferes with his use and enjoyment of the downtown waterfront and parks. He is an abutter in the same neighborhood as the Golden Anchor's pier, and he regularly uses and enjoys the affected downtown area. This court has found sufficient interest on lesser grounds in cases like Black, Fitzgerald, and Conservation Law Foundation. So this second criteria is that his interest may be impaired by the disposition of this action.
Can I ask a question, counsel? I see that the green light is on.
Yes, Your Honor.
Is the interest which your client would have to have in order to have mandatory intervention, is that the same as an interest, a particularized interest for standing? I mean, you've cited a whole lot of standing cases.
So that's because we are our position is that we do have standing
Well,
to intervene.
I understand your position is that you have standing,
But standing and interest to intervene are two distinct concepts.
tell me the difference.
There is no particularized injury requirement for for interest to intervene.
So you're saying it's a lower standard than standing?
It is, yes, and I'll tell you why. Because to intervene, you just have to show an interest, the three criteria that we're discussing, right? But then in order to separately appeal a finding of the lower court, you can no longer ride coattails. There's a whole coattails doctrine, right? And an appellate court needs to find that the appellant needs to have independent standing. He can no longer ride the coattails of the original
Well, I understand
party.
you must have independent standing. I'm struggling to understand why you think that the interest that the applicant claims, which is the subject of the action, and is so situated that disposition may, as a practical matter, impair or impede his ability to protect that interest. I'm confused why you think that is a lesser interest than the kind of interest that is required to have standing.
Because there are plenty of instances where an intervener is allowed to intervene at the trial court level.
That may be permissive intervention, and it may be, if Mr. Sidman had been permitted to intervene in this case, we would still be looking at abuse of discretion if the other side had appealed, right?
Yeah, but the standard is the same for for intervention as of right, and there are plenty of instances where somebody is allowed.
Standard for intervention as of right is the same as what?
Permissive intervention.
You're saying those are the same standards?
No, but in terms of standing, yes, because there are plenty of instances where somebody is allowed to intervene as of right in the trial court, but then not allowed to appeal because he doesn't have standing to appeal, right? And so it is a lesser standard if you let in a ton of people at the trial level, but then don't allow them to separately appeal because they don't have standing. That means that intervention is, in fact, a lower bar.
But when you intervene, you become a party.
Yeah.
Correct.
So you can appeal. That's like the big difference.
No, appellate standing is something different. You're no longer allowed to ride the coattails of the original party. You need to show that you have standing to appeal. So it is a different standard, and it is a lower bar.
When you've been granted party status, you have to show separately standing on the appeal?
Yeah, there's a whole federal doctrine over appellate standing called
Do we
the
have a state doctrine that says that?
No, we don't. Sorry, we do
And
not.
our standing is prudential.
And standing is prudential, right? So it's arguably more
Can we move on to
permissive.
adequate representation?
Yes, adequate representation. And so the town is conflicted here from from defending this litigation. The town is operating a town-owned pier to disembark cruise ship passengers, and that's like a municipality operating a quarry themselves and reluctantly having to enforce blasting regulations.
But the town is defending the litigation.
So they can't make certain arguments, and I'm going to try to get into this. Golden Anchor claims that it has a lawful pre-existing right, a lawful non-conforming right to disembark cruise ship passengers. The town is incapable of challenging that because they are disembarking cruise ship passengers in the same exact district, the Shoreline General Development 1 district. And so our position, as it's always been, has that this has never been an allowed use, and you can't have a vested right in an illegal use. And so the town is conflicted from making this argument because it is actively disembarking cruise ship passengers themselves in the same district. The only use that allows the disembarkation of cruise ship passengers is a passenger terminal, and any use not specifically allowed is specifically disallowed under the ordinances. And so the only district where the disembarkation of cruise ship passengers is allowed is in the Maritime Activities District a mile down the road. And understandably, the town government doesn't want to have people come in and be brought in a mile down the road. They want to support the downtown shops that depend on cruise ship industries, the cruise ship industry. And so they are conflicted from making these arguments themselves, which is at the heart of this litigation.
As a matter of law, or just conflicted as a matter of rationale?
This is a practical conflict,
Are you
yes.
arguing that any representation is patently inadequate, or simply that it may be inadequate under the circumstances?
Well, the standard is may be inadequate, and we think that we've beyond proven that it may be inadequate.
Because of the conflict?
Because of the conflict of the town disembarking cruise ship passengers themselves. Because the town government tried to actively vote down the ordinance at issue in 2022.
Well, can I focus a little on your first argument? It's because you want to make arguments that you're saying the town, as a practical matter, won't make, correct?
It's not that they won't make, it's that they can't make them because they're disembarking cruise ship passengers in the same district. So they're never going to argue that it's not an allowed use.
Well, they could argue it, couldn't they?
I think that them disembarking cruise ship passengers themselves stops them from making these arguments, and also making the argument that Golden Anchor abandoned that use during the 18 months of COVID restrictions, where not a single cruise ship passenger disembarked on their pier.
I guess, counsel, I'm a bit confused. You're suggesting that there's a problem with disembarking, period, but wouldn't that be separate litigation that you can then bring to challenge the town's zoning ordinance? Why would it be raised here?
So this is at the heart of this case, because Golden Anchor is claiming a grandfathered or vested right to disembark because they have a non-conforming use. And so the immediate, most obvious defense is you can't have a vested right because you can't have a vested right in an illegal use. And the town is never going to argue that because they're doing the same thing. And so it is relevant to this
Well, if they
litigation.
had a vested right, if they make that argument, the argument would be that it vested before the passage of the ordinance, right? I mean, you don't, when you say you can't have a vested right in an illegal use, I mean.
If you look back, even back to the 1970 version, there is no allowable use to disembark cruise ship passengers in this district, right? And that's been our position from the get-go. Yes, the ordinance was passed, but there was another ordinance passed in 2020. It doesn't really change anything. The ordinance restricts cruise ship passengers in a different way, but to defend the vested
You're talking about
right.
Chapter 22 versus the initiated?
Chapter 52 and the
52.
ordinance are identical. Like there is no distinction. Golden Anchor is challenging the 1,000-person passenger limit. They're challenging the permitting requirements. It's all the same. The ordinance and the rules of enforcement, which are codified at Chapter 52, are the things at the heart of this litigation. And if Golden Anchor has a vested right to disembark cruise ship passengers, it would undo both of them, because they have had a monopoly on disembarking cruise ship passengers for the last 30 years.
What's the source of that vested right?
They're claiming that they have some sort of construction permits that allowed it, but then there's an ordinance. The ordinance under nonconformity is what they're really relying on, that they have a legal nonconforming right to disembark cruise ship passengers. And they don't need to apply for a permit, and they don't need to abide by the 1,000-passenger limit.
Thank you, counsel.
Thank you. We would just ask that Mr. Sidman be allowed to intervene because his interests are not adequately represented by the town.
Thank you. Attorney Hunter?
Thank you, Your Honor. Good morning. May it please the court. Charles Sidman is appealing from the denial of his motion to intervene in this case. And my brother, Counsel Papazian, has already discussed the three-part analysis under Rule 24A2. Even if one were to accept Mr. Sidman's claim that he has an interest in this case, and I believe Attorney Woodcock will address those claims, the motion was still properly denied because the town adequately represents any interest he has in seeing the town's ordinances enforced. A private party that's seeking to intervene alongside a government has a greater burden because they have to overcome the presumption that the government adequately represents related private interests. Mr. Sidman has not carried that burden here. Golden Acre is challenging in this case Chapter 52 of the Town Code relating to cruise ship disembarkations and a related notice of violation that was issued by the town for failure to obtain necessary permits. Chapter 52 was adopted by the Town Council to implement an earlier citizen-initiated ordinance that's now codified at Section 12577H of the Town Code, of which Mr. Sidman was a proponent when it was initiated. That citizen-initiated ordinance was and is the subject of federal litigation brought by Golden Acre and others. Mr. Sidman successfully moved to intervene in that case, with the district court finding on the very limited record that was before it that Mr. Sidman had raised a sufficient question as to whether the town would defend Section 12577H. Mr. Sidman's motion here is substantially similar and rests on sort of the same premise that the town will not vigorously defend Chapter 52. But that premise, as the business court found, is belied by the significantly different circumstances and much more extensive record that was before the business court in this case. Since the voters of Bar Harbor made their will known by adopting Section 12577H, the town has consistently and vigorously defended, implemented, and enforced it. First, the town successfully defended Section 12577H in the federal litigation. It then implemented Section 12577H by adopting Chapter 52, and then it immediately took action to enforce those ordinances within days of Chapter 52 becoming effective. In a very real sense, this case...
Green light's on. What about the argument they've raised that the town is, not just that they want to raise additional arguments, but the town doesn't have the capacity to raise arguments that they want to?
So first, I would just cite Your Honor to the Rosenfeld case, which says that a private party's interest in making different arguments in defense is not
Correct.
enough.
That's not enough.
And then second of all, none of that stuff that Mr. Papazian was talking about in terms of the town pier, that's not in the record before this court. Justice Lopez brought up, isn't this something that should be brought in a different matter? Well, it has been brought in a different matter. There's a matter pending in the business court right now in which Mr. Sidman has challenged the town pier and whether that's an allowed use in the district. So it's really irrelevant to this appeal. And basically what Mr. Sidman is trying to argue there is that the notice of violation here was under-inclusive because it only cited Golden Acre for permitting violations and not for supposed zoning violations. And we just don't think that Mr. Sidman really has the right to dictate how the town enforces its ordinances. So,
If the standard is that the representation may be inadequate, that seems to set a low bar. I assume it's your argument that even with a low bar, they haven't gotten over that hurdle.
yes, Your Honor, and I think as the court has noted, that it's an abuse of discretion standard. So maybe the business court could have come to a different conclusion here that would have been appropriate under that standard. But I think it would be very difficult for this court to say that the business court, looking at this record, abused its discretion.
Apart from what the record shows, just let me ask you this. Does that argument that appellant is raising carry any freight in this case?
Well, recognizing that I'm departing from the record that's before this court, I don't believe the relevant ordinances are in the record here. But it's very clear that permanent piers are allowed in this zoning district. These piers have been in this zone for decades. That passenger terminal use that Mr. Papazian referenced, that was only added to the code in the past decade.
But your point is none of that is before us anyway.
It isn't.
So we don't even have the ordinances, as you've said, in the record, and we can't take judicial notice of them.
No, that's correct, Your Honor. And again, that issue is currently, it was before the Board of Appeals, the local Board of Appeals, and now it's on an ADB appeal to the BCD.
There don't appear to be additional questions for you.
Thank you, Your Honor.
Attorney Woodcock?
Court. I'd like to address just a couple of points here. First, the 24A talks in terms of the transaction, that the intervener has to have an interest in the transaction. The transaction here is a challenge to the validity of
Property or transaction, whatever that means, but.
Right. I think in this case, it's probably the transaction because we're talking about the validity of an ordinance and an enforcement action, so that's why I'm using it that way. And I think the business court got it right when it said that what is at stake here is not a challenge to the 1,000-person limit. I mean, that has been litigated in another forum. What is at stake here is whether and how the enforcement of this 1,000-person limit pursuant to this new law, Chapter 52, how does that apply? Is that valid? That is what we are challenging. So that is the transaction that is issued. It's that transaction.
If you phrase it narrowly like that, is it your position that he might otherwise, if it was phrased broadly, have a sufficient interest in the transaction, but if it's phrased narrowly in that sense, that he does not?
Well, I think what governs it is what is at issue. What are we claiming? So what we are claiming is, in a variety of ways, Chapter 52, which was enacted back by the Town Council in June 18 of 2024, is invalid. It's invalid as an ultra vires exercise of the Town Council's authority. It is invalid in certain material respects. But that's really a challenge. It's an as-applied challenge in a sense because it's arising out of an enforcement action. But that is what we're challenging, is essentially the validity of Chapter 52. And again, it's in response to an enforcement action against us. I would also like to add, there is a critical element here that I think the court needs to focus on, and that is Mr. Sidman's interest. You've heard representations as to Mr. Sidman's interest in this matter. There is a claim that he has an economic interest in this matter. And there, I think, and I would really urge the court to focus on this, the evidence of that is in Mr. Sidman's affidavit. Mr. Sidman submitted an affidavit as part of his motion to intervene. That is where you will find the representation as to what his interest is. There are representations made in the pleadings that go well beyond what Mr. Sidman himself, based on his personal knowledge, was willing to say.
Well, counsel, let me ask you this. I mean, is there anything in Mr. Sidman's application that would be to intervene that's really any different than any other business owner in Bar Harbor? In other words, isn't certainly retail business in Bar Harbor, whether positively or negatively affected, I mean, they must be affected by the number of cruise passengers?
Well, I mean, again, I think in that respect, we're talking in a sense outside the record because we don't really have a record on how each one of these businesses is affected. And you would expect, I think it's reasonable to expect there's some kind of impact, but that's just a reasonable inference, I suppose. What we're looking at here, what is Mr. Sidman saying is his interest. What is he saying he's being affected by? And that is in his affidavit. And I would really urge the court to look very closely at it. Most of his representations with respect to the effect on him are on A107. And with respect to what he says, and I'll quote him, "We are adversely affected by large crowds of cruise ship passengers who disembark in the town during cruise ship season, which lasts primarily from May through October each year." That is essentially what he says about the adverse impact. When you look through his affidavit, do you find, I've lost money? No. Does he say, I have to close my store? No. He says some businesses or some customers come on different days, and that's in his testimony under oath, which was appended to our motion, but nowhere does he say that he suffers a business loss. because of the cruise ship passengers. The most he says in his affidavit is, we are adversely affected.
Well, he says his clientele refuses to come to his place of business because of these disembarkations.
He says they refuse to come on those days. But in his testimony under oath, which is attached to our motion, that is the Golden Anchor motion, he said, they just come on other days. So there wasn't he didn't say, there is no point anywhere, either in his deposition testimony, which is part of our opposition to his motion, or in his affidavit where he says he actually has been economically injured. It's not in there anywhere. And in that respect, I would urge the court then to look very, very closely at representations that go well beyond that were made in the counsel's brief. And these include assertions that that Mr. Sidman's business rises and falls with Golden Anchor's ability to disembark cruise ship passengers. That's in the appellate brief at page 26. There's nothing in his affidavit that supports that. That is a statement that goes well beyond Mr. Sidman's representations. And I would submit to the court, if you are an attorney and you're making a representation to the court, and the basis of that representation is your client's affidavit, you cannot go beyond that affidavit. You cannot make representations in excess of the representations that are made in the affidavit. And there are repeated representations that go beyond this very vague reference to being adversely affected. Thank you very much.
And Mr. Papazian, you asked to be heard in rebuttal.
Thank you, Your Honors. So the standard is potential economic harm, and that's discussed in Patch. And contrary to what my adversaries are saying, there is concrete harm to Mr. Sidman's business. He actually closed his second location closer to the piers because of the congestion and downtown chaos that's caused by cruise ship passengers.
And that's in the record?
That is in the record, yes. That is in our affidavit. And so, yes, we do want to make additional arguments.
But this isn't a challenge to the 1,000-passenger limit.
It is, and they've pled that in their complaint. They don't want to be beholden to the 1,000-passenger limit. They capitalized the P in that argument to try to distinguish it from the federal litigation, but it doesn't really matter. It's still challenging the 1,000-passenger limit. And they're also don't want to be beholden to the permitting requirements that are the same in the ordinance.
Well, I mean, they're bound by res judicata.
They are.
As to whatever is in the federal litigation.
Yep, but they're still trying to re-raise these arguments here, which is the problem. And so, yes, we are trying to raise additional arguments from the town, but those arguments are at the heart of the litigation. And in Daggett, they discuss that it's not raising different arguments doesn't make representation inadequate per se. Quote, but one can imagine cases where, even in the absence of a conflict of interest, a refusal to present obvious arguments could be so extreme as to justify the finding that representation by an existing party was inadequate. And so we do have a conflict here, but beyond the conflict, we have so many other instances where the town government was trying to undermine this ordinance. They actively campaigned in 2022. They opposed Mr. Sidman's...
But haven't those been superseded by their actions in connection with the federal proceedings and what's taken place since with the adoption of the disembarkation ordinance?
Yes, and so we certainly were participating in that and trying to hold the town government's feet to the fire in the federal litigation to actually defend the litigation. And we successfully did that. And we worked well together with the town attorneys, but the town attorneys aren't the ones calling the shots. And so the town council was the one that suspended the enforcement during the 2023 season. They suspended the enforcement in the 2024 season, and then they started disembarking cruise ship passengers during the 2025 season themselves. They even sought to repeal the ordinance itself during the November 2024 election. That was a year ago while we were arguing this motion to intervene. And so the town is supporting other interests, broader interests that are adversarial to Mr. Sidman. It's like the town supporting the quarry industry and masons and other miners, and has no interest in defending the interests of the china shop here, which is Mr. Sidman's business.
Thank you.
Thank you, Your Honor.
Thank you, counsel. As is our usual practice, we will take this matter under advisement, issuing a written decision in due course. Mr. Papazian, is it my understanding that you are a member of the Maine Bar? You're not here on a pro hac, right? And that this is your first appearance in front of this court? And as a result, our tradition is to ask counsel to come back and take the greetings of the court. And co-counsel are welcome, although we may be a little crowded. And we will be in recess on this matter.
All rise.
Good morning. You can be seated. The matter before the court is Penobscot 24-581, Cunningham versus Cunningham. And we are being streamed on the web, both by audio and by video. If counsel are prepared, I'd ask first that you introduce yourselves by saying your names for the record, together with the party you represent, starting with the appellant.
Good morning, Your Honors. My name is Peter Boss. I represent Karen Cunningham, the appellant.
Good morning, Your Honors. Attorney William Johnson for Andrew Cunningham.
Thank you. And Attorney Boss, if you're ready to proceed, we'd be happy to hear your argument this morning.
Thank you, Your Honor. I don't want to repeat too much that's in my brief, but I think the focus for me would be the court's addressing what we believe was non-marital property, which created a conflict in the court's order. This relates to a lump sum settlement that she received sometime during the course of the marriage. We understand the burden of proof, obviously, is on the plaintiff in that situation.
Since you decided you'd let your green light stay on, can I just jump in?
Please.
And with regard to the payments in the future, did the judge, I mean, he set those aside to her. Did the judge consider that as part of the marital property or not? In other words, the medical payments that she's entitled to receive into the future after the divorce.
So there was two components. Excuse me. There was this medical benefit component, which very clearly was paid into the future before or even during the course of the marriage, as well after the marriage. There was also this more of a lump sum amount.
Right, and I'm asking only about the future payments at this point. What did the judge do with did the judge, let me back up. The judge classified the lump sum settlement, for better or for worse, as marital property. And I understand that you contest that. Did the judge classify the future payments that she is going to get as anything?
The judge did, from my review, the judge did not classify that either way, either marital or non-marital. So there leaves a question as to how those amounts are going to be treated in the future.
I mean, she gets them, it's...
Yes.
Okay.
What, do you agree that it's non-marital?
I'm sorry?
Do you agree that that is the future medical expense set aside is non-marital?
Yeah, absolutely, yes, yes.
That was a softball question.
And what about the future annuity payments?
Well, that's a more open question, Your Honor. So there's a lack of clarification, I think, in the court's order about treating both components of that. The medical payments appear to be those going to Ms. Cunningham in the future. The other portion of the lump sum portion, which portion of it was purchased by, or an annuity was purchased for that, clearly he's described that entirely as marital. Our argument would be that that's not particularly that clear because of how the court's order is written in terms of the medical payment.
But just looking at it in the abstract, if you will, the lump sum payment itself, which was received during the marriage, that if that had been taken as a lump sum at the time it was received, that would be marital property, wouldn't it?
I don't necessarily agree with that argument.
Why?
Well, it certainly a portion of that represents wages. And a portion of those wages could also be wages attributable to her in the future.
But isn't the burden on the party asserting a non-marital interest to not only say, gee, some of it's non-marital, but how much, and to parse it out? And that was the judge required to find in this case that it was adequately, it compels a finding that a certain amount, a quantifiable amount, is non-marital.
I agree with that analysis. That's correct. The burden is on us. The burden is on the proponent of that argument to show first that it's non-marital, and then give some idea as to what that.
And isn't part of the problem here is that the settlement documents don't really break it all out nicely the way they sometimes do when we're contemplating divorce?
I certainly would agree with that, Your Honor.
Well, don't you have a further problem that in the context of the divorce judgment itself, the court laid out the fact that from its perspective, the parties didn't provide the court with enough evidence for it to make a determination, and nobody filed a motion for further findings of fact. Isn't that problematic?
Well, no, not from my vantage point, Your Honor. So with respect to the findings of facts, he put his findings very specifically. Those findings, unfortunately, are inconsistent. Now, that may be due to a lack of development of evidence during the course of the hearing, or the document itself that laid out the settlement proceeds. But first off, I don't think we needed to file a motion for further facts because he stated facts and he made his conclusions. Unfortunately, those conclusions, though, were inconsistent.
Could we go back to where we started, which is with the future medical benefits? And you suggested that the court's order is ambiguous as to whether those were treated as marital or non-marital. Is that, do I have the first?
No, I think I was maybe a little confused about the question. I think those benefits are payable to Ms. Cunningham in the future.
Okay, and so what is your argument as to what the court did with those benefits? Did the court make any error, I guess, is my question. Sure. Is that your argument?
So that's correct. So my understanding, Your Honor, is the first step is to first determine separate property, and then move on to moving that separate property to the person it belongs to, and then make an equitable distribution of the marital estate. Our argument is, in determining that there's an inconsistency in what the court determined to be separate property, which not only included the wage benefit, where he said that is paid in the future, but also the other portion, the lump sum portion of that as well. So when he failed to make that determination, that clear determination, now with respect to the amounts, that's a different issue.
Okay.
But then going on to divide the marital property as if the separate property has been already taken care of, that's where we believe there was the mistake.
Okay, so no error in the way the court treated the future medical payment, just error in the way the court treated the lump sum.
Correct.
That helps me, thank you.
And you agree, I understand you're contesting as to whether the lump sum should be viewed as entirely marital, right?
Could be, but not entirely. Again, I'm not in a position to say X amount of that is non-marital, X amount of that is marital. And what I'm saying is that calculation should have been at least identified in the order.
What calculation?
There was no calculation. I mean, the only thing.
Well, what are you saying should be identified in the order? I guess I didn't follow that.
So my understanding of the order, reading the order, is that the court found that there was no non-marital property, but then went on to say that there's wage benefits that are going to be payable in the future have been addressed. But he characterized that in the order as marital property, or the entire lump sum settlement, which included the wage benefit.
But if I could be clear, if this were not a workers' comp settlement, but suppose that one of the parties won the lottery during the marriage, and instead of taking the lump sum, decided to annuitize it, the future payments from that lottery winnings are marital property, aren't they? Wouldn't the court be properly considering those as marital property?
Correct.
And what's the difference here, and what's the deficiency in the record?
The deficiency is a portion of that settlement not only represented medical benefits, which we've already talked about, but also represented lost wages in the future, wages that would have been earned in the future when they were not married, as opposed to winning a lottery is like receiving a gift from...
But again, isn't it on you, isn't the burden on you to parse that out? And the judge found it wasn't adequately parsed out, therefore it's all marital. I mean, the annuity payments in the future are still based on funds that were received during the marriage.
We never got to that point because the court, in its order, decided that there was no non-marital property. So what would we be parsing out at that point if there's no...
So what are you claiming is non-marital then?
What I'm claiming is non-marital, first off, make absolutely sure that the medical payments that go in the future
Okay,
belong to
medical
her.
payments in the future.
And
That's one
secondly,
piece.
the other component was the lump sum amount, I guess is for lack of a better...
That was received during the marriage.
Correct.
For an injury that occurred before the marriage, I understand that.
Correct.
And the judge found that it wasn't adequately, didn't have sufficient evidence to show the specific components of the settlement money that was non-marital, and therefore it's all marital. What's wrong with that finding?
We think, again, that the way the order is written, what the order says is that there was no non-marital property. and yet there was.
But wouldn't it have been incumbent then on Ms. Cunningham to file a motion for further findings of fact, to have the court flesh that out? And because that didn't happen, aren't we in a different posture looking at this as an appellate court?
Well, I think you're reviewing it from the same posture, Your Honor. But in retrospect, obviously, a motion for further findings on the issue perhaps could have been helpful to the court.
Well, particularly where the court says the court wasn't given adequate evidence from the court's perspective to do anything beyond what it did in the judgment. So at that point, you're on notice that to the extent that you think the court's wrong, the court doesn't think it had sufficient evidence to make that determination. And that's why I asked the question that I asked before. Isn't it problematic to the extent that there wasn't a motion for further findings of fact to help the court get to the point where you thought the court needed to get to?
So the court's order didn't say, at least in my reading of it, didn't say that I can't find any non-marital component to this particular lump sum settlement. I'm declaring, or I'm finding, that the entire lump sum settlement,
Well,
even though...
counsel, what do you make then of, and I am quoting, both parties received settlement payments during the course of the marriage for injuries incurred prior to marriage. Generally, all property acquired after marriage is presumed to be marital. The spouse arguing that property acquired after marriage is non-marital has the burden of proving a non-marital component. Because neither party here presented sufficient evidence to show that a specific component of the settlement monies were non-marital, the court concludes that all funds received were marital. Isn't that exactly the finding? That there's a failure of proof.
But then he goes on to say that there's a portion there that is non-marital. In other words, the medical benefit payments paid into the future is non-marital. So there's an inconsistency in between.
But that's not, well, okay, I guess I'm confused, but.
So are you saying that the order of the divorce court should have said X% of the lump sum should be deemed non-marital? And what would be the X?
It certainly could have said that. I mean, it could have said a set amount, could have said an X amount, could have some other way of calculating that, yes.
Is it inconsistent? It says that all funds received were marital property. So doesn't that by its terms exclude funds that haven't been received yet?
It says all funds received. All funds were received whenever, I can't remember what the date of the settlement was, during the course of the marriage.
Well, the annuity investment that was from funds received during the marriage, but the future payment of the medical expenses wasn't received, was it?
No.
Okay. All right, thank you.
Thank you.
I think you reserve 3 minutes. We can come back to you.
Thank you.
Attorney Johnson?
Yes, good morning, Your Honor. I didn't reserve any time either, so if the court would like to jump in with questions, I'd be happy to go that route.
What's your position on those future medical expense dollars?
I think the burden was on Ms. Cunningham to prove that there was a non-marital component in there, and she utterly failed to do so.
For future medical that she hasn't yet received, that was pretty set separately, wasn't it?
It's a medical set-aside, ostensibly. When you look at the only evidence of what that is, it's
It's 8,000 something a year, right?
Well, that's contained in Plaintiff's Exhibit 20, which is an unsigned draft. We don't know if that's the actual settlement.
But everybody kind of agreed that that was the best evidence of what the settlement was, wasn't it?
Well, I think we clarified on the record that it was unsigned, and we don't know what it is. This is part of the discovery problem that we had in this case.
All right. So are you suggesting that in the order here, the judge found that the future medical expense payments were marital?
The term marital versus non-marital was not used. It certainly was awarded to Ms. Cunningham, and I could certainly see a line of logic that would say that, yes, those are non-marital. That's a non-marital component. Anything that she's to receive after the date of marriage.
Future medical expenses that haven't been incurred yet, isn't that sort of by definition non-marital?
Yeah, that's exactly what I was just trying to say. Maybe I didn't say it clearly enough. I could certainly see why the court would be concerned with that it wasn't specifically labeled as non-marital.
So you're not arguing that she's not entitled to, let's say, that $8,000 after the divorce?
Not at all, Your Honor.
She's entitled to that?
Not at all, Your Honor. I am saying that I think it's unfortunate that the court didn't set it aside specifically and say this is the non-marital component, but the result is the same. I think I will concede that I think the continuous $8,000 and some change future medical set-aside payments are Ms. Cunningham's non-marital property.
So just so I'm clear, you're saying that was error?
I'm saying that it should have been specified more clearly. It was set aside to her.
That there may be some ambiguity,
I think there's some ambiguity.
but it was set aside to her in any event.
Yes.
Does that infect, however, since what we asked a judge to do, and he didn't specifically set it aside as non-marital, which is the first step in the division of property, but instead it seems to have all been lumped together?
No, Your Honor.
Let me
I'm
finish.
so sorry.
Does that infect the division of marital property?
I don't think so at all, Your Honor. I think that that is an insignificant error, if it is an error. I think it's an insignificant ambiguity. I don't think that would affect the three-step analysis otherwise.
Can we assume or infer that the judge intended that? Should we say that in our decision?
I sure would like to. I think this is just an absence of the term set aside as non-marital. It was awarded to her.
Yeah, but one can't award it if it wasn't marital in the first place.
Understood. Yeah, I agree with that, Your Honor. I think it's an unfortunate omission in the judgment.
Why do you argue, though, that it doesn't impact the ultimate distribution?
Well, because if you look down the sort of the line in the thought process on why the Lebanon Road property might be non-marital, that claim also fails, because obviously here...
But that's different. I mean, that was from, that property was purchased with funds received in whatever year it was, 2010 or whatever, during the marriage, from the settlement, correct?
Sure, but Ms. Cunningham's argument at trial and her argument here in the brief is that the Lebanon property is non-marital because it was purchased with a lump sum.
Oh, I understand, and that depends on whether the lump sum that was received during the marriage is classified as marital or non-marital.
So what you're looking at, in my opinion, is because that's marital property, I think that the omission of not calling the future medical set-aside marital versus non-marital is sort of insignificant in and of itself, as in I do not think it would have affected the distribution of the other property.
But ordinarily, when we vacate one portion of the financials in a divorce, we sort of vacate all of it, or say the judge can, because it may have, we don't know, affected how the judge did the division. If it was incorrect, if it's incorrect to have classified one thing, then we say, it may not. Maybe they'll end up at the same place on remand, but, we don't know that.
And I don't think that this is a situation where that aspect of future payments that are going to be received by Ms. Cunningham, inevitably, it really doesn't upset the analysis here. It's to the benefit of Ms.
So you're
Cunningham.
suggesting the court could have taken into account, if it had characterized it as non-marital,
yes, sir.
would have set it aside, could have taken it into account, and likely would have ended up in the same place?
Yes, I think that if they had taken it into account as non-marital, they could have looked further at the equities and the...
They could have. The question is, would the judge have done that, right?
Your Honor, I think that only benefits Mr. Cunningham. I think if you're going to set aside $8,000 in future income, or whatever we want to call it, to Ms. Cunningham, then I think the court then looks overall at the equities of the case, and one of the things the court can look at is the overall property distribution, including what is set aside as marital versus non-marital, in giving a fair and just property distribution.
I'm not sure I understand how it benefits.
Well, the court could say that in dividing what's remaining as marital property, the court would look at, as a non-marital asset of Ms. Cunningham, an $8,000 plus future payment.
Right, but it could not consider that as part of the property being divided.
No, it could not, and it could never award it to Mr. Cunningham. I agree with that. But it would also, like I said, I don't think taking that out of the marital pot impacts...
Well, certainly one can look at what non-marital assets an individual has in making a just and equitable division of the marital property, but it's really not it's not a one-to-one. It's not like, okay, it's now even because she got all this on non-marital.
It's not a one-to-one. I agree with that, Your Honor, but if there's any slight advantage to one party over the other, I think it hedges that way. I don't think it would I think it's insignificant enough where it would not, it would not affect the overall property distribution.
And how do we know that?
I guess looking at the overall marital estate, it's a relatively insignificant component.
Well, given their incomes, it's not so insignificant, is it?
Well, compared to the equities in the houses and the properties and the other allocations in the case.
There don't appear to be additional questions.
If I may, I would just like to say that I want to be very clear that it's just fraught with ambiguity. I'm not sure from the testimony from the record whether the lump sum was then used to, I think what the judge found was the lump sum settlement was then used to purchase an annuity. So I don't think that there's any significance to the fact that future annuity payments will be paid going forward. I think it's marital property, purchased with marital property. So it's.
Well, I think that if the judge is correct or sustainable, let's put it that way, affirmable, in finding that the lump sum monies received during the marriage were marital, then it would follow that the annuity and the real estate were also marital because it was purchased with those funds.
Yes, and there was just a line of questioning from one of the justices. I can't remember who it was. I just want to clarify my position on that.
Well,
With that, I have.
would you agree, though, that if it was a workers' compensation lump sum settlement, and there may be some components of that which would not qualify as marital property going forward?
Certainly, but in this case, it's.
But it's
Ms.
a failure of
Cunningham's-
proof. It's a failure of the record.
This is a burden-shifting analysis
Yeah.
at its essence.
Right.
Nothing further. Thank you.
Thank you. Attorney Boss, you reserve some time for rebuttal?
I did, Your Honor, although I'm just here to answer any other questions. I don't have anything else to add.
There don't appear to be any.
Thank you.
Okay, thank you. Thank you, counsel, for your argument here this morning. As is our usual practice, we will be taking this matter under advisement and will issue a written decision in due course. And with that, we're in recess for the lunch break.
All rise. We are in recess. Thank you, appreciate it.